Hello everyone, welcome to Abhyarthi IAS, Day 7 of Target UPSC Prelims MCQs 2024. Let us begin. With reference to electoral roll, consider the following statements. No person can be enrolled as an elector more than once in any electoral roll. It is mandatory to provide Aadhaar details of the applicant to get registered in the electoral roll. No homeless person who does not possess documentary proof of ordinary residence is eligible for registration as an elector. How many of the statements given above are not correct? So the answer would be B. Statement number 2 and 3 are not correct. Statement number 1 is correct. So recently, the Election Commission of India said that the largest electorate in the world, which is 96.88 crore, are registered to vote for the forthcoming general election 2024. So statement 1 is correct because in India, a person cannot be enrolled as a voter at more than one place as per section 17 and 18 of Representation of People Act 1950. Likewise, no person can be enrolled as an elector more than once in any electoral roll. So any person, while applying for a fresh enrollment, he or she has to make a statement or declaration that his or her name is not included in any electoral roll of any other constituency. And if such declaration is found to be false, then that person is liable to be punished under Section 31 of Representation of People Act 1950. The statement 2 is not correct because according to Election Commission of India, it is not mandatory to provide the Aadhaar details of the applicant. जो registration form होता है उस पे आधार डिटेल्स मांगी गई होती हैं but it is not necessary to give your आधार details. तो इसका मतलब ये है कि it is purely voluntary and the non-submission of Aadhaar details, it is not a ground for the rejection of application by the electoral registration officer. Likewise, statement number 3 is also not correct because in case of a homeless person who does not have a documentary proof of ordinary residence, the booth level officer will visit the address given in Form 6 during the night so that the booth level officer can ascertain that the homeless person actually sleeps at that place which he or she has given as an address in form number 6. So it is given that the booth level officer must visit the same place which is given as the address more than one night for verification purposes. And if the electoral registration officer is satisfied that all the prescribed conditions are fulfilled, so the homeless person will be enrolled in the electoral roll. Additionally, what is the condition given for getting registered in an electoral roll? It is that the applicant should be an Indian citizen and should be of 18 years or more of age, and the applicant should be an ordinary resident of the area concerned. Moreover, how can one get registered or enrolled in the electoral roll? As mentioned earlier, one has to file an application for this purpose under the Form 6 before the electoral registration officer or assistant electoral registration officer of the constituency within which the place of ordinary resident of the applicant falls. Next question. Which of the following statements are correct about Digital Personal Data Protection Act 2023? It covers personal data in both digital and non-digital format and subsequently digitized in India. Under the Digital Personal Data Protection Act, state agencies may be exempted from its position at the government's discretion. Personal data can be included and processed only with explicit consent from the individual with no exemption. We have to select how many of the statements are correct. So the answer would be B. That is only statement number 1 and 2 are correct and statement number 3 is incorrect. Digital Personal Data Bill received President assent in August 2023. Statement 1 is correct because Digital Personal Data Protection Act is now in effect and governs the processing of digital personal data in India, regardless of whether the data was originally collected in digital or non-digital format and subsequently digitized. Statement 2 is correct because Digital Personal Data Protection Act it aims to establish a higher level of accountability for the entities operating within India including the internet companies, mobile apps, businesses involved in the collection, data, and processing of citizens' data. The right to privacy is strongly emphasized within the Act so as to ensure that the entities which are dealing with the personal data they should be held accountable. However, it has been given that under this act the state agencies may be exempted from its provisions at the government's discretion. Data Protection Act will also have implications for India's trade negotiation with other countries. This act aligns with global data protection standards. It takes inspirations from various models like European Union's General Data Protection Regulations and China's Personal Information Protection Law. Statement 3 is not correct because the personal data will be included and processed only with explicit consent from the individual unless specific circumstances which deals with national security, law and order requires otherwise. So therefore there are some specific exceptional circumstances in which the consent of individual will not be required. Data Protection Act beyond the border of India भी apply होता है. It also covers those digital personal data processing activities which took place abroad. ये specifically उन organizations के ऊपर apply होता है which offers goods or services to individuals in India or which engage in the profiling of Indian citizens. Under this act, the individuals also have the right to information, right to correction and erasure, right to grievance redressal, and the individuals also have the right to nominate any other person to exercise the above given rights in the event of individual's death or incapacity. So at present, there is no specified timeline for implementation of grievance redressal and data principal rights. Next question. With reference to Telecommunication Act 2023, consider the following statements. The Act covers broadcasting, over-the-top services and satellite-based communication services. Telecom operators have been mandated to capture verifiable biometrics data when they issue a new connection. The Act provides for refunding the spectrum price paid by the entities for its allocation if authorization is suspended. How many of the statements given above are not correct? So the answer would be B. So the statement number 1 and 3 are not correct, but statement number 2 is correct. The President gave his assent to Telecommunication Act of 2023 in December 2024. Statement 1 is not correct because the Telecommunication Act of 2023 excludes from its ambit broadcasting over-the-top services such as WhatsApp and Telegram, while in the question we were given that the Act covers these such services, which would be incorrect. The Telecommunication Act of 2023 has repealed the Indian Telegraph Act 1885, Indian Wireless Telegraphy Act 1933, and Telegraph Wires Unlawful Possession Act 1950. Moreover, it also amends the Telecom Regulatory Authority of India Act 1997, which is also known as TRI Act 1997. The Telecommunication Act cements rules for spectrum allocation and it provides for an administrative route which is non-auction route for assigning airways for satellite-based communication services. The spectrum will be assigned by auction except for specified uses where it will be allocated on an administrative basis. Statement 2 is correct because under the Telecommunication Act, the telecom operator will have to be mandated to capture verifiable data when they issue a new connection. Statement number 3 is not correct because under the Telecommunication Act, there is no such provisions of refund of spectrum price paid by the entities for the spectrum allocation. In the Act, it is specifically mentioned that no person shall be entitled to the refund of any fees or charges paid in respect of or under an authorization or assignment granted under this Act, if such authorization or assignment is suspended, curtailed, revoked, or varied. But it has to be noted that under the Act, the central government can permit sharing, trading, leasing, and surrender of assigned spectrum, subject to various terms and conditions, including the applicable fees and charges, which are also prescribed in the Act. Next question. Consider the following statements. Statement 1. District collectors are obliged to respond to summons issued by the Enforcement Directorate. Statement 2. The Prevention of Money Laundering Act allows the Enforcement Directorate to probe the money laundering aspect of crimes registered by the police on various states. So we have to select whether the statement 2 is the best and correct explanation for statement 1. So the answer would be A, that is statement 1 and 2 both are correct and statement 2 is the correct explanation for statement 1. Recently, the Enforcement Directorate froze 123 crore which was kept in bank account of NIUM India Private Limited on the behalf of Singapore-based Shell Company. It was in connection of a case involving illegal online loans, gambling and betting apps. Statement 1 and 2 are correct because Prevention of Money Laundering Act (PMLA) allows the Enforcement Directorate to probe the money laundering aspect of crimes which are registered by the police in various states. So there was a recent case in which the Supreme Court of India directed four district collectors in Tamil Nadu to appear and respond to the summons issued by the Directorate in the illegal sand mining case. So what the court stated that the district collectors and persons to whom the summons have been issued, they are obliged to respect those summons. Moreover, Supreme Court of India ने ये भी emphasize किया कि under Section 52 of Prevention of Money Laundering Act, Enforcement Directorate is empowered to summon any person whose attendance was considered necessary for giving evidence or production of records in course of any investigation or proceeding under the Prevention of Money Laundering Act. To put it in simple words, Section 53 क्या करता है, ये मैंडेटरी कर देता है कि जिस भी इंडिविजुअल को समन पास किया है that individual is bound to attend in person or through authorized agent before the enforcement directorate and would be required to make truthful statements and produce the required documents which are asked by the enforcement directorate. Next question. With reference to Uniform Civil Code, consider the following statements. Uniform Civil Code is part of Part 4 of Indian Constitution, which includes the directive principles of state policy. Uttarakhand has become the first state in independent India to implement Uniform Civil Code. People of all religion in Goa are subject to same laws on marriage, divorce and succession. We have to select which of the following statements are correct. So the answer would be D, that all of the statements are correct. So as per the statement 1, the Uniform Civil Code is a part of Part 4 of the Constitution which includes the directive principle of state policies. Part 4 में Article 44 ये specifically provide करता है कि states shall endeavour to secure for citizens a uniform civil code throughout the territory of India. The debate regarding the Uniform Civil Code and its implementation dates back to constituent assemblies, wherein B.R. Ambedkar believed that Uniform Civil Code was necessary to promote gender equality, secularism, and national integration. Statement 2 is correct because Uttarakhand has become the first state in independent India to implement a Uniform Civil Code. Moreover, Uttarakhand government ने ये भी क्लियर किया है कि the members belonging to scheduled tribes Uniform Civil Code इन पे लागू नहीं होगा. Statement 3 is also correct because a version of Uniform Civil Code is in place in Goa, which is also known as Portuguese Civil Code of 1867. It states that people of all religion in Goa, whether Hindu, Muslim or Christians, they are all subject to same laws on marriage, divorce and succession. It should be noted that Muslims who register their marriages in Goa, they are prohibited from engaging in polygamy and triple talaq. Moreover, the Uniform Civil Code it permits equitable distribution of wealth and income between husband and wife as well as between their offsprings. It is also provided that the children cannot be completely disinherited by their parents and they must inherit at least half of their possessions. But there are some flaws in Goa Uniform Civil Code. The Catholics enjoy certain privileges such as exemption from marriage registration and ability of Catholic priests to dissolve marriages. So in a way, Goa Uniform Civil Code gives some privileges to Catholics which are not given to any other religions. And the church is given primacy in dealing with various matters relating to marriage and inheritance of the Catholics, such as the Catholics can solemnize their marriages in church after obtaining a no objection certificate from the civil registrar, while for the person of other religions, only a civil registration of marriage is accepted as a proof of marriage. It does not recognize bigamy or polygamy, including for Muslims, but it grants an exception to a Hindu man to marry once again if his wife does not conceive a child by the age of 21 or if a male child is not conceived by the age of 30. So this would be all for today. Thank you for discussion. Please like the video and subscribe to Abhyarti IAS.